You got released and you're, oh, happy day, I'm released and I'm just going to live my life. I will deny the motion. That party's announced for the record for the state.
Daniel Escobar for the state of Texas.
Defense.
Joseph Stateson for Ms. Wells.
And are you Ms. Wells? All right. And Mr. Stateson, when were you appointed to represent Ms. Wells?
I was appointed today. I explained that to my client that she had 10 days for me to prepare for any hearing. And we both agreed to waive that notice of appearance. Waive the 10 days notice.
All right. Ms. Wells, do you wish to continue? All right. And you understand that your attorney does have 10 days to prepare?
Yes, ma'am.
All right. And knowing that you wish to continue with the motion to revoke? All right. You need to speak up. All right. I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Jacqueline Ann Wells who was placed on deferred adjudication in 2022 CR 3998 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on July 7, 2022 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Jacqueline N. Wells, did then and there fail to report to the supervision officer as directed for the months of November and December 2022 in violation of condition number 4.
How do you plead to that? True or not true?
State waives all the violations.
Any objections?
None.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? I'm sorry, number 4? Court will find violation of condition number 4 true. Is there an agreement?
Yes, Your Honor. The agreement is for the motion to be granted and for revocation and for 10 months in the state jail facility.
All right, is that the agreement?
It is, Your Honor, and we would ask that all her back time credit apply. She has 139 days credit.
Okay.
And then the state's also going to take into consideration NIMAG number 713316.
All right, Ms. Wells, are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am. Yes, ma'am.
All right, I have a few questions for your client.
Yes.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Jacqueline Wells. Yes.
All right, Ms. Wells, where have you been?
Have I been? I've been in Bexar County.
No, I mean, you haven't been doing your probation. Why not? What's been going on?
I know last time that I came, I was supposed to be going to Stateson. That's what you recommended. And whenever I was waiting for my treatment bed in jail, Bexar County, I wasn't aware that, I just got released without any paperwork. So I don't know.
And so you got released and you're, oh, happy day, I'm released and I'm just going to live my life.
Honestly, I thought that I had just gotten time served or something. I didn't understand why I just got released, but I thought that I don't know. I just know it wasn't static. So other than that,
Okay. So I want you to be honest with me, okay? I'm looking at following this plea bargain agreement, but I want to know some things about you. And then, depending on what you tell me, I will probably give you a choice, okay? But the 10 months will definitely be one of those choices. So do you have any children?
Yes.
And how old are they?
One is 15 and the other one's 9.
Right, and where are they?
With the dads.
Okay. And was Child Protective Services involved? And what drugs have you been using since you were released?
Since I was released, meth.
Meth?
Alcohol.
Okay, meth and alcohol. It appears to the court that you have a drug problem and you need to have that drug problem taken care of. Otherwise, you know what's going to end up happening? The last time you use may be the last time you use, and then your children will definitely not have their mother in their life. You still have a chance. Maybe if you get yourself together, if you get clean and sober, you may still have a chance to be in their life. But you must be clean and sober. And the fact that you were released accidentally or whatever happened, and you've been using, I appreciate your honesty telling me that you've been using. That tells me that you need help. So if you would like, I can send you to the state jail facility for 10 months. What's going to end up happening is you're going to go to state jail facility for 10 months. You'll do your time. You're counted off on the calendar, and you are going to get back out and you will use again. Or I can continue you, and I'll continue you, and I'll have you placed in an inpatient treatment, or either see if felony drug court would accept her or wants her. Have you ever been to felony drug court?
Mm-hmm.
Those are the choices I can give you. So if you want to do your 10 months, I will follow that agreement, but you know yourself better than I do, better than your attorney does. But based upon your track record, when you get out of jail or state jail facility after counting your 10 months off, you're going to go use. You're going to go be with whomever you were with before who's using with you. And you may end up dying from that. You understand? So if you want a chance to be clean and sober, to be the person you were meant to be, not the person who's picking up criminal cases, not the person who's using, then I will give you that chance to do that. So what would you prefer?
The chance.
Okay. All right. So what we're going to do,
Your Honor, may I?
yes.
So I just want the court to be aware that she wasn't actually let go erroneous or anything like that.
Mhm.
She was disqualified from status.
Okay.
So she had medical issues that prohibited her to actually go to status.
Yes.
So in looking at the case, the modifications were after status based on her previous NTR. This is her third NTR.
Okay.
So based on previous NTRs that we've had, the modifications the last time was to do status, and then after that, a felony drug court. So if Your Honor would like, we can just move forward with the felony drug court referral, see if we could get her the help that she needs.
All right. We're going to then, if both state and the defense are in agreement, I will deny the motion, alternate amend conditions. You'll be referred to felony drug court. You're going to remain in custody. And Mr. Stateson, if you can contact felony drug court and let them know that she really needs the help and she wants the help. But when they come in and interview you, you must really let them know that you need the help, because I know they're getting close to probably reaching the number of persons they can have there. Do you understand? All right. So what I'm going to do then.
And I apologize, ma'am.
Yes. Yes.
It does state that she expires in July of 2024. So
We'll extend her. Yes. So I'm going to extend you, and I'm going to extend you for 2 years. But the nature of your case, it's not a case where if you complete everything that you can't be terminated early. And normally in felony drug court, if you complete everything and you complete their program, they will allow you to be terminated early. Terminated is not a bad thing on the criminal side. It's not like the
Early discharge.
yes, it is not. What's the name of the movie with Arnold Schwarzenegger?
Terminator.
Terminator. It's not the Terminator. So you will not be terminated in that way. It will be a good way. So I'm finding violation of condition number 4 true. I'm going to extend her for 2 years, and we'll do a referral to felony drug court. And that's to take place while you are in custody. And if for any reason you get released, you know you're not supposed to be released. So if you are accidentally released or something is not right with the paperwork and they release you, you know what you need to do? Come straight to this court right away and say, Judge, I've been released and I know I'm not supposed to be released. Do you understand? All right. So this is your chance. You need to take it. All right. Is there anything else from either side?
No, Your Honor.
if she does not qualify for felony drug court, would you like clients to?
Yes. If she doesn't, If she's not eligible, then bring her back here from the jail and we'll figure out what to do. And we'll keep Mr. Stetson, if you could make sure that you follow through till
Okay.
she's accepted.
Yes, Your Honor.
All right, thank you. Is there anything else?
Nothing, Your Honor.
All right, thank you.
Abstain.
Defense?
Probation, Your Honor.
And are you Demario Jones? All right, I'm going to show you what's entitled Motion to Revoke Community Supervision and State's motion to supplement pending motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Demario Jones who's placed on community supervision in 2019 CR 7581 for the offense of assault, bodily injury, family household on October 31st, 2019 for a term of 2 years? Is that you?
Yes, ma'am.
All right, State.
Yes, in violation of condition number 2, on or about the 9th day of December 2019 in Bexar County, Texas, the defendant, Demario Jones, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, at this time, we'll waive and abandon the remaining violations.
Any objections?
No objections, Your Honor.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to a $4,000 fine and up to 1 year in the Bexar County Jail?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there an agreement?
Your Honor, I believe there's an agreement to revocation. However, the state is requesting the underlying 1 year. And I believe defense is going to request the court to reform that.
That's
Oh,
correct.
right. So the state is requesting 1 year. Defense, what are you requesting?
Your Honor, I would request the court to reform the judgment. I'm not trying to make any excuses for my client. He did do some drug testing and it was negative, and he did do some others. It's because he was working and he was gone. The court knows from the supplemental. But as the court can also see, he did not pick up any new offenses. He's been out 2.5 years working, raising his family. And that's not an excuse, Your Honor. Just let the court know that he's been trying to do right, except for he should have been reporting. He's telling me his mother is in Florida. She recently, within the last year, has been diagnosed with cancer and was wanting to go visit her and wants to get back to work as soon as possible so he can make money to do that. So he will visit her, and I'm asking for the final judgment. I'd like to see the court reform it. He has 103 days credit at this time, Your Honor. If the court could reform it to 206 days or somewhere around there, they give that, or if not, maybe a 30-day jail sanction, so he understands that he did do something wrong on that.
So what did he do while he's been on probation?
Did
he do the class?
he started some classes and he did not finish the classes.
All right.
He did do some testing and was negative on. He was positive on the first test. I think when the first one, and everyone after that he did was negative, but he did not show up on some other.
All right. Any objection to the court reviewing the court summary, probation's court summary?
No.
All right. So what I see here is he was exited from the Battering Intervention and Prevention Program on October 20th, 2020. He was given an opportunity to re-enroll in the class, and then he was unsuccessfully discharged on February 8, 2021. He hasn't done parenting classes. Have you done parenting classes?
No, ma'am.
So he hasn't done anything. All right. Is there anything else from either side?
No, Your Honor.
That's my client. What, do you want to say anything?
Okay. All right. This is what the court is going to do. The court will grant the motion. Court is going to sentence you to 1 year in the Bexar County Jail. There's an affirmative finding of family violence. There's to be no contact with Leanna, Leighhanna Gonzalez, Gonzalez. Give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, you have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand?
Yes, ma'am.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, good luck to you. Do better, okay?
He promised the court he'd change. He lied. Diario Jones skipped his drug tests, got kicked out of his classes, and never finished parenting counseling, the exact conditions of his probation. His lawyer begged for mercy, pointing to his job, his clean record since. Judge Stephanie Boyd wasn't buying it. 1 year, Behar County Jail, and a permanent order. Stay away from his victim forever.